everyone. Welcome back to Will's Trust and More. And of course, I have Eileen Kerlin Walsh. Welcome back.
Thank you,
co-hosting with me. And Eileen is going to be talking about something very special, very unique, actually. We're going to be talking about trust for special needs planning. And that could be for an adult, a child, and it'll be very interesting to hear what is really special needs planning.
Ron, special needs planning is planning for the care of a disabled adult or child, someone that you care for now, making plans to care for them in the future when you're no longer there, when you're no longer able to do that for them. And for someone who does have a disabled family member, this is a very frightening, often overwhelming thought. What's going to happen when I'm no longer here? So special needs planning is getting into the arena of giving them peace of mind, showing them what their options are, and planning for that day.
Yeah, what are the options that are available for a family member that has that concern?
Okay, typically we do special needs planning, and we do that within the estate plan. Historically, families who did have that disabled adult had very few choices when they viewed that frightening day when they were no longer there. If they had some resources and perhaps there's other siblings, they would either leave money to that child because that felt like the right thing to do and they knew that child had these great needs. But by leaving money directly to the child, they risked the benefits that the child would have been already receiving. Many special needs adults are receiving SSI and Medicaid, that's supplemental security income, and Medicaid, which are state and federal benefits designed to help those disabled adults.
Now, excuse me one second. Now, for those people, adults or whatever, receiving those programs, or receiving on those programs, would that be prior to the parent passing away? Would that plan already be in place, or does that happen after?
Oh, that's interesting, because we can sometimes plan for a child who's already receiving benefits or who may become eligible in the future. So when we're doing the planning, we consider that those benefits either are already available or will become available in the future. And those benefits are often available for someone who has no more than $2,000 in the bank. Typically, parents take care of their disabled children up until they're 18. When that child becomes 18, they really then are an independent adult. And often at that point, they do become eligible for benefits. And we're actually very good here in the US and federally and statewide about taking care of those very dependent adults. There often are benefits available. And these benefits, Ron, contrary to popular belief, are not just for the poor. The federal and state laws that provide for them encourage that kind of planning. So what we're really looking at is planning for the basic needs of that very disabled person. It could be physical, it could be mental, it could be developmental, but we want to get their basic needs taken care of with the state and federal benefits that are available for those needs. Then we want the parents' resources, if they do have extra, for the non-basic needs and for life enhancement. So special needs planning, because of those very valuable benefits. And Ron, often when we do have someone who's either physically handicapped or disabled, we can have really high, very expensive, sometimes sophisticated medical care, expensive care. And if that's covered by Medicaid, then we often want to make sure that those benefits are not even interrupted while we go through a probate.
Right.
We really want to make sure, because it's going to be distressing enough for the disabled adult to lose their primary caregiver, and this is so distressing and painful for parents who've cared for their disabled child maybe all their life. The last thing we need, in addition to the loss and the grief, is for this child now to have benefits. And even if the parents leave them $100,000, suddenly to lose all these benefits and have to spend down that money and then reapply is just not a good result. And if we can get estate planning done on time and special needs planning incorporated with our estate planning, we can make sure that doesn't happen. And that's probably one of the most important aspects of advanced estate planning special needs planning, whether it's for benefits that might be future eligible or for benefits that the child or the adult is receiving that we don't want to interrupt.
Now, are there any special requirements to develop this trust?
Yes, these trusts do have to be specially drafted. You absolutely want to make sure that when you're drafting it, that you meet those state and federal requirements. A general needs trust, which often is what parents are thinking about, they know their disabled adult is not able to take care of themselves. So they're thinking about leaving money for that adult, who's going to take care of that adult, but they're not thinking about what we need to do to prevent loss of benefits. So the most important special requirement is that language, and that language is in the form of instructions to the trustee, and it's very limited in what the trustee can pay if it would affect those benefits. And because then those benefits continue uninterrupted, the monies that the parent is leaving for the disabled child can be used for all those extra benefits. And again, as I say, state and federally, the law is very generous for what that extra money can be used for, and there's no cap on what we can leave the disabled person. And as long as it's correctly drafted, regardless of how much is in there, our disabled adult can continue to receive their benefits. And that's the most important part of special needs planning. It's not the only part. Of course, we do realize that disabled adult cannot care for themselves, so we have to make sure that their money is protected from creditors, from predators. We have to make sure that it's set up in such a way that we can trust whomever is taking care of the funds. Often what parents used to do, either they disinherited the child, or if they have 3 siblings, they would leave 2 shares to another sibling to take care, because they would have known, that parent knew that they would lose benefits by leaving it to that child. So what we have seen is that even if the sibling had honorable intentions, and sometimes they might not, even if they intend to take care of their disabled sibling, their folly or a divorcing spouse could have eaten into that share. So these special needs trusts, and there are many different kinds, Ron, but we don't want to overwhelm our audience with talking about the different kinds, and certainly we could do another show on OBRA trusts, there are payback trusts, there are pooled, self-settled, third party, but overwhelmingly a simple third party special needs trust takes care of what our clients need.
Wow. You just covered an umbrella of all kinds of factors that have to be taken into consideration. Because after someone is gone, will someone else in the family possibly abuse those funds? And all of that has to be thought out. It's
Absolutely.
unbelievable. Any other considerations that...
Well, you bring up the consideration of who will the trustee be,
Yeah.
because, and again, Ron, I take really seriously our responsibility as counselors, and our parents want to preserve family harmony. So they say, well, should I make the sibling the trustee? And a sibling, if we have a nice, trustworthy sibling who's prepared to do it, is a good choice in many ways, much less expensive than a professional trustee. But what if the trustee isn't completely reliable, or what if the disabled adult resents the fact that it's their sibling controlling their money? And as is the case with many of the trusts we talk about, a professional trustee is a terrific option, but we always let the client know that is an expensive option. And this special needs trust now is going to last for a very long time. This is not a child who, once they turn 30, is going to get the rest of their money and they're done. This is someone who's going to need those assets taken care of
for the rest of their life.
For the rest of their lives.
Yeah.
So the importance of the trustee is one of the huge considerations. Absolutely.
I had no idea. Of course, all the things you had just mentioned have to be taken into consideration. And you just don't realize that until someone that has been involved with it and have planned for this brings this to light. Anything you want to add to in concluding this little topic?
Well, our clients will often say, well, do I just do a special needs trust for my disabled adult? And of course the answer is no. It has to be incorporated with their overall estate plan. So if our clients are doing a living trust, we'll maybe incorporate the special needs trust into the living trust. Not every client needs a living trust. So what if they're just doing a will? Well, we can certainly incorporate the special needs trust into their will, but that doesn't avoid probate. So again, if we have modest assets where we don't need that living trust, we might just do a standalone special needs trust, refer to it in the will. And then we're still not done. We always have to look at each of the assets that the parents have. And a good rule of thumb is anywhere you would be naming that child individually, now name their trust. So a retirement account, if it's perhaps an IRA and the other children want to be named individually rather than through a trust, name the other children and then name the trust of the disabled beneficiary. So never name them individually, always create the trust and then name them under the trust. There's another couple of considerations, and these are not legal documents, but as you know now, and as our viewers will know, I always try to take the big picture into consideration, and again, look at those other perhaps siblings and see how they're going to feel about all of this. And I often recommend an ethical will, and we've done shows on this being a document that's not a legal document, but really it's about explanation and a little bit of a love letter. And sometimes if the special needs child has received more benefits than some of the others, and sometimes it can be less because of the public benefits, sometimes it's more because of the great need. So if there's an inequity amongst siblings, I always tell the parents, let's try and explain it as much as possible. So I would recommend a letter of explanation. And then also maybe a letter of intent to the guardians, to the trustee, to the family members, how to take care of that person, you know, what their medical needs are, what their behavior management is, what their likes and dislikes are, so that the transition at the loss of a parent is not going to be as dramatic, because this is a tremendously difficult thing for the parent of a disabled child to anticipate, knowing how close that relationship has been. And because this disabled adult has not just flown the nest like, you know, non-disabled children do, it's a great way to be able to give the parent as much peace of mind as possible. And Ron, as you may or may not know, we recently had National Autism Awareness Week.
Right.
One in 68 now in the US has some form of autism. That was surprising to me. So really the realm of special needs planning, it really opens up with that, and it's so important to get it done in time. Another reason to get it done in time is when the parent or the caregiver is competent. I have seen the really sad scenario where we have had the parent of a Down syndrome child never do any special needs planning, cared for that child so wonderfully all their competent life, become incapacitated, develop Alzheimer's without doing any planning. So now we don't have any plan in place for the parent and no way to protect that child with the parent's assets. So what do I always say? The time is now, and for those who do have a special needs family member, you know, disabled family member, that child with a developmental disability, it's so important to get the estate planning done
early,
as early as possible. Get it into place, because this special needs trust doesn't have to be funded now. It can just get tucked in with that estate plan. It doesn't have to be created until after the parent passes. Now, if it's within a will, clearly that can never be funded until after the parent passes. But if it's standalone, it could be funded during the parent's life. And sometimes we take into consideration, what if the special needs child receives an inheritance from a grandparent or a gift from some other source? Even $5,000 from an aunt would affect those benefits. So when we do estate planning, we write a letter to give to the parent, to give to anyone who might be considering leaving a gift for the disabled person, so that they know to leave it to the special needs trust. So there's just all good reasons and no reason not to get it in place early. And I have spoken to many parents of disabled children, and this weighs on them because of that extra responsibility, because that child is not leaving, is not going to college and going off to forge their own way in the world. And it's amazing how good they feel when they get it done.
Right, and you really hit on something that is really sensitive, and that is for the parent that has all these concerns. And obviously not only for the child or the person that needs the assistance after they're gone, and because they're disabled, but it's the rest of the family understanding what the wishes are and communicating and leaving that communication documents that you had mentioned for the family, so they understand what is expected from them, as well as what you expect to see happen for that disabled person.
Absolutely. The needs, their intentions, and then of course it's our job to give those intentions legal effect, so that the trustee knows what needs to be done and what they have a legal obligation to do. And it does give the parents tremendous peace of mind.
Yes, it sure does. It's kind of intense to create all that initially, that once that's over with and documented, and you say, wow, am I glad it's over with, and I know my family is going to be taken care of.
Absolutely.
Eileen, I want to mention to the viewers that I'm sure there's going to be some questions, and we're going to put your phone number at the bottom of the screen.
Wonderful.
And if they were to call you, you could respond and answer them or questions?
Absolutely. Absolutely. We can talk about special needs. We can even help with the benefits that are available and how to qualify for them. That's another question. Many parents think that if they are well situated in life, that means that there is no help available for their children. And as I said previously, Ron, they often think that those Medicaid and the SSI is only for the poor. So I think it's very encouraging for them to know that their child will qualify, can qualify, and have the benefits and the resources that they have can go for the non-basic needs. One other subject I think we'd be remiss not to mention when we're advising the parents of special needs children or other family members, but it's often the parent who needs this help, is guardianship. Now, again, that's the subject of another show. We've talked about it before. We'll talk about it again. But when a disabled child reaches 18, the law does not recognize that disability without a guardianship. And even if a parent is a named beneficiary, perhaps on a Social Security benefit, they still don't have the continuation of that legal guardianship without going to court. So when I do special needs planning, in addition to the trust, which is really for the future, we always talk about getting that guardianship in place also. It can be guardianship of the person, of the estate, of both. Oftentimes, if there is no estate, if there is no money for this child beyond what the parents are providing, it's really just about the person. And there's minimal reporting for the courts, but it is something that parents do consider and need to consider, and we would recommend getting that in place also. So guardianship for the continued legal care of them during your lifetime, and special needs planning for after your lifetime does provide that peace of mind that many of our clients are looking for.
Excellent topic, Eileen. I thank you for bringing that to the viewers. And again, for the viewers who have any question, give Eileen a call. Her number again is at the bottom of the screen, and her address is also there at 1301 South Harlem Avenue. She's in our community, so she's readily available, and as she said, she'll be answering any questions that you may have to send to her or meet with her. Well, thank you again, Eileen. We will see you in about a month, and Eileen will be bringing us another very interesting, unique topic, and we'll see you soon.
My pleasure. Thank you,
Ron. Have a good one, Eileen.
Thank you.
Bye-bye.